Alrighty, so welcome to our review for the semester of criminal law. And I'm going to share my screen. I've got a PowerPoint that's going to walk us through the semester of work that we did. Alrighty, so the first thing that we look at with crimes is the fact that we're always dealing with a criminal statute. That not since the 1800s have we had crimes defined by common law, that is judge-made law. So since then, we've been dealing with things that a legislature will pass and then codify. So we're always going to be looking to a statute when we're asking the fundamental question of whether someone has violated a criminal law. So that means we've got to look at these things and understand how to go about interpreting a statute. So we first look at the types of things that these statutes will contain. Actus reus, mens rea are two things that will either be in every single criminal statute or their omission will be something we are having to talk about. So let's start right there. So actus reus, that is the act. Have you affirmatively, voluntarily done something? There are times when the failure to act is itself a crime. For instance, not paying your taxes or not feeding your child. That would be a culpable failure to act, but it would be defined in the statute. So either the act or the failure to act will be part of what's in the statute. Mens rea. Normally, there will be a mens rea element. Sometimes that's described poorly as an intent element. Loosely speaking, it's sometimes described as intent. The reason that's problematic is because intent is a particular type of mens rea. It means the desire to commit a crime. And as we've learned in this class, the desire to commit a crime is not always required. If you are aware that you will be violating this crime, or aware that the circumstances that you're about to undertake will amount to a violation, or you're reckless with regard to that, that can absolutely be sufficient, depending on the statute, to be a violation of a crime. But the mens rea requirement is typically going to be something that every crime contains. There are times when it doesn't, and those are called strict liability crimes. Those are normally reserved for what are called public welfare offenses, things from which your unintentional, unknowing, innocent, accidental act or failure to act can cause widespread damage to society. We don't ask if you knew you were drunk when you got behind the wheel of a car, because the potential damage to society of your getting behind the wheel of a car is so enormous. Society says you take the risk if after having had anything to drink, you get behind the wheel of a car, because we're looking to protect society from widespread damage. Or more commonly, if you manufacture drugs, you've got to ensure that those drugs contain exactly what you say they contain, so that you don't cause illness or death to everyone who gets the wrong drug. So mens rea is very common in a statute. In those rare instances where it is strict liability, we will be asking the question, did the legislature truly intend to leave out this mens rea term, or was the omission simply something the legislature left for us to fill in, for us as courts, for us as lawyers, to understand that because it's common for there to be a mens rea term, that it will be in this case as well. So we'll ask, actus reus will be defined for us. Mens rea, may or may not be by the legislature. If it's not, we're asking the question, did they mean to leave it out? If so, it's strict liability. If not, then what do we fill in for that gap? So we then look at results and causation, but let me just actually dwell a little bit longer on mens rea. It is fairly uncommon to see a strict liability crime. It is not terribly uncommon to see that one of the actus reus elements of the crime is strict liability. So for instance, it's not at all uncommon in a drug statute to say if you intentionally possess drugs, then you're guilty of unlawful possession, say with the intent to distribute. And then if you possess this amount of drugs, you're guilty of a felony 1. If you're guilty of possessing marijuana, felony 3 or misdemeanor or whatever. The type of drug that you're possessing or the amount of drug you're possessing may well be described in a statute without a mens rea term. So while it's uncommon to have a purely strict liability statute, it is not at all uncommon to have a statute that has a mens rea term with regard to some elements, with some actus reus, and then to have no mens rea term with regard to either attendant circumstances or other acts. So, if you could imagine use of force, like, the intentional taking with force. Does that imply that the force had to be intentional? Or is it that if you use force at all while you're intending to unlawfully take something, that would be sufficient for robbery? So these are questions you have to ask with regard to each element of the crime, that there could be strict liability aspects, either as to actus reus terms or as to the attendant circumstances. What was the unlawful substance you were possessing? How much of it did you possess? Those could be strict liability components within an overall statute that would not be regarded to be strict liability. The other two terms you'll have of a statute are only sometimes there: results and causation. Homicide is the best example I can think of a crime that involves a required result. If no one dies, that's merely an assault of some sort. If someone dies, it's homicide. The result has to happen, and the cause has to be the defendant's action if he or she is to be guilty of the homicide offense. Causation is an incredibly important point. Understanding that the result has to come from the action of the defendant. I have never given an exam in which I don't in some way test causation. It's going to be on your exam somehow, some way. It always is. Results are always spelled out in a statute, but the causation requirement almost never is. Unlike mens rea, we never imagine a statute that doesn't have a causation requirement. We assume that's always there. And in fact, I've never seen a statute written that omits the causation requirement expressly. I've never seen them that include it either, but courts have never said causation is not a requirement if the result is an element of the crime. So as you interpret these statutes, you'll look for those elements, you'll look for the missing terms and figure out what to do with them. And then you'll ask, as you go about interpreting this language, what can we use to help in our interpretation? Where does the language come from? Was it borrowed from somewhere else where in that context, it has been interpreted to mean one thing or the other? The most common form of this borrowing of language, I compared it to retweeting in class, is when it comes from the model penal code. Because very often with the model penal code, the commentators have helpful comments that have shown what they meant when they wrote it. And because a lot of states have adopted the model penal code provisions, we have interpretations by other courts. So when a legislature takes that language, we assume that it brings with it the interpretations that have that have accompanied it elsewhere. Finally, we'll want to ask, when we're looking at a statute, what policy is being advanced with this particular interpretation of the statute? What is the goal? If we interpret it one way versus the other, what sorts of interests are we protecting? What kind of activity are we deterring? On what basis are we punishing the defendant? And is that policy analysis consistent or inconsistent with what we assume our legislature has done in this or other contexts? A great example of this would be Justice Saylor's opinions regarding the Pinkerton liability for conspiracy. He says, if you look at the way the Pennsylvania legislature has defined the extent of a defendant's culpability under or liability under complicity, it can't be that the policy that animates that would be inconsistent with the policy that animates the scope of liability, or the scope of liability under conspiracy law. So we're looking for consistency. We're looking for hints of what might be driving the legislature's thinking when it adopts particular language. So we then started to look at particular statutes that identify the types of crimes that you're familiar with. And homicide is the one with which you are, the most familiar from TV shows and watching the news. In Pennsylvania, there are 5 different types of homicide. First degree, as you know, requires intent, the desire to kill. Now, we have also learned that that intent can be formed in a very brief period of time. We talked about the Derek Chauvin case and how that if the prosecution had wanted to, they absolutely could have charged first-degree murder there, because the period of the strangulation, it's not like he has to walk up to the scene with the desire to kill George Floyd. If at any point during the strangulation, he concludes that is his wish, then he's guilty of first-degree murder. And if you were looking to prove that in that case, you would say, why would you continue to choke after consciousness is gone unless your desire was affirmatively to kill? This can be formed in an instant. We're looking for things that show intent, the use of a weapon, the method of the killing, where were the shots, where were the stab wounds, is there any length of time here between the obtaining of the weapon and the action? With regard to the Chauvin case, there actually are cases that conclude that strangulation, because you actually are watching the life expire in your hands, that is per se proof of first-degree murder. It wasn't charged that way in Chauvin, but it could have been. Second-degree murder is felony murder. And this means that during the course of your robbery, your rape, your burglary, or your arson, that someone dies. They have to die, somehow connected with what you've done. It can't be that a lightning bolt strikes the person on the head as you're robbing the bank. But if in any way, if the robbery victim has a heart attack because of the stress, then that could well be regarded as a causal effect of your decision to rob the bank. So for felony murder in Pennsylvania, it has to be one of those 4 types of felonies, but we don't have to show anything more than the fact that you were engaged in one of those acts. Now, to go back to the Chauvin trial for a second, Minnesota obviously has a broader range of things you can look to for the underlying felony. This case, you want to follow this case with regard to second-degree murder. This case could well be reversed because it is the assault that they used as the predicate for felony murder. And as we know in Pennsylvania, that would merge, because what we would be saying is that your assault was the felony that led to the homicide. And if you do that, if you say that the assault itself, the act of killing, is the felony that then leads to death, well then, because there will be an act of killing in every killing by definition, then everything could default to second-degree murder, and you've just completely obliterated all these other distinctions. The state of Washington has done that, but I'm aware of no other jurisdiction that has. I don't know Minnesota that well, but I could imagine the second-degree murder conviction in Chauvin's case being reversed. Third-degree murder, this one won't be reversed in Chauvin's case. This is malice. A lot of states will describe this as second-degree murder. This is described in a number of formulations in statutes across the country. And in fact, the Pennsylvania cases we've looked at describe third-degree murder with a variety of different formulations. Cold-blooded, depraved heart, depraved indifference, you'll see. In Pennsylvania, one of the really interesting formulations is that if you have recklessness with regard to the life of the person that you're doing something to, then that shows malice. The reason that's problematic is because involuntary manslaughter is recklessness to the possibility of serious bodily injury. And we've talked about in class how that, jurors, particularly given the fact that intent can be shown with truly so little, that whether you regard an act that's not planned out well in advance to show the intent to kill being developed somewhere in the very quick actions of the defendant, whether you regard the actions of the defendant to be malice or recklessness with regard to serious bodily injury, all three of those could fit into a whole lot of scenarios with really little ability to parse the distinction between them. And as we looked at in our final substantive class, the penalties for a first-time offender in Pennsylvania, first-degree murder is life. Third-degree murder is 6 years, and then involuntary manslaughter is 3 months. And all of those jury instructions are, in my view, practically indistinguishable for an ordinary juror. Final category of homicide is voluntary manslaughter, killing in the heat of passion. So, you're engaged in a fight with someone, and just as the fight is ending, you shoot the person. You're both really, really amped up. You've inflicted pretty substantial injuries on one another, mutual combat, you take it up a notch. Alternatively, if you are, one of the definitions of voluntary manslaughter is that if you believe that you have to kill someone to save your own life, and you're wrong, and you're not just wrong, but unreasonably wrong. We'll get to self-defense later, but if you reasonably believe you have to kill someone to save yourself or others, you're allowed to do so. But if you are completely unreasonable in that belief, but that is your belief, then your crime is voluntary manslaughter. And in some ways, you could imagine that also being a type of heat of passion. If you think someone's about to kill you or someone else, you're going to be fairly amped up. That's not strictly speaking regarded as heat of passion, but you can see it fitting in that same generic category. We're going to now look at assault. And assault is nice because particularly the aggravated assault statute does a good job of showing you how or what you have to do when you're interpreting these fairly complicated statutes. Simple assault, ordinary assault is, and if you look at this, there are a variety of ways to show it, and it looks at a different mens rea terms depending on what actually happened or how you went about doing it. If you attempt to cause or intentionally, knowingly, or recklessly cause bodily injury. What do we mean here by bodily injury? We've seen in the cases, any kind of pain, any kind of anything can constitute bodily injury. But it has to be intentional, knowing, or reckless. If, however, you're simply negligent with a deadly weapon and you cause some kind of bodily injury, your gun causes like a slight nick on a person's skin, but nothing really, then you're guilty of ordinary assault, even if you're just negligently handling the gun. And then if you are attempting to intimidate someone by your physical prowess, you're trying to put someone in fear of imminent bodily injury, then you've also assaulted that person. Aggravated assault is a great example. Aggravated assault won't be on your exam. But I think you would be very wise to go back and look at it. The reason I tell you it's not on it, because I'm going to walk you through all of these categories and show you what you need to be looking for as you interpret statutes, or one of the things you're going to need to be looking for. You're going to need to be looking for what these words mean in this context, what's missing and what's different. Because when you look at this statute to start with, it looks like they're all kind of the same, but there are important differences between each of them. So the first one, attempts serious bodily injury or intentionally, knowingly, or recklessly causes it. Now, if you pull the original statute, you will see that recklessly in that first prong says reckless with regard to the life of a human being. When you skip down to the second one, or even the last one, you'll see attempts to cause or intentionally, knowingly, or recklessly causes, and I have in parentheses simple. There, the reckless was not modified with, in the statute, was not modified with the phrase with regard to the life of another human being. What that then means is you're reckless with regard to the possibility of seriously injuring somebody, or injuring someone, depending on the degree of harm that's required by that particular prong. So that distinction is important to look at. The distinction between 1 and 2 in this is you've got the difference between reckless bodily injury, recklessly with regard to the risk to life, or simple recklessness. And there, if your assault is upon an officer, simple recklessness will do for serious bodily injury, whereas for everyone else, it's got to be recklessness with regard to the possibility of killing someone. The third prong, attempts bodily injury or knowingly or intentionally causes an officer to suffer. So if you're dealing with an officer, and there are a few other people identified in the statute, but if you're dealing with a police officer, then you're going up to aggravated assault if you intentionally or knowingly inflict anything on an officer. You punch an officer, you flick the ear of an officer. You're now at the level of aggravated assault. Whereas if it's not an officer, we'll remember from this last slide, this is attempts to cause intentionally, knowingly, or recklessly causes bodily injury. That's not of an officer. So you go from simple to aggravated based on the identity of the offender. You attempt to cause or intentionally or knowingly cause bodily injury to another with a weapon. So now, ordinary bodily injury, go back to the previous slide, if you negligently cause bodily injury of any sort, however minor, with a deadly weapon, then you are guilty of simple assault. But if your mens rea is intentional or knowing, you're now at the level of aggravated assault. Attempts by physical menace to put officer in fear of serious bodily injury, that's aggravated assault. And then our final two, attempts to cause or intentionally, knowingly, or recklessly causes bodily injury to a child less than 6, or then skip down to the final one, attempts to cause or intentionally, knowingly, or recklessly causes serious bodily injury to a child less than 13. Why are those two there? What makes them different? Well, if the child is under 6, any kind of bodily injury. If the child is between 6 and 13, then it has to be serious bodily injury. So this is a great statute to work through. And I know because I've told you it's not going to be on the exam, you're now going to ignore it, but I do not recommend you do that. In fact, I recommend you parse this statute very carefully for the final, because walking through that and learning how to identify terms and statutes that are different, that you need to understand and need to appreciate, will serve you very well on this exam. Property crimes, I'm going to walk through those. There's a lot more detail in the statutes themselves, but we went through that kind of analysis with aggravated assault. So I'm not going to redo that with these crimes. I'm going to lay out for you the basic gist, but there are details about the nature of each of these crimes that will, in the statute, make them more or less aggravated. But the basics of all these crimes are identified here. Theft is an unlawful taking of property with the intent to permanently deprive. The desire in taking this, you have to not have a claim to that property, and you have to have the desire not to give it back. And that's distinguished from joyriding, the desire to temporarily deprive a person of property. And that gets very complicated because we created special statutes when cars came along, but we didn't limit that to cars. So we created joyriding statutes that basically said temporarily depriving people of property. And that got all messy because of modern property, things like concert tickets, to use an easy example. So Pennsylvania then went in and created a whole mess of theft offenses that would cover theft of services, thefts of rental property, et cetera, et cetera. So we then move to robbery, theft plus force. Just that simple. The nature of the force you use will change the character of the robbery and the punishment for it greatly, but you just have to plow through that statute and look at all the possibilities. Burglary, again, there are multiple ways to commit this, whether it's a house versus a gas station, whether someone's in there or not. Those are the particulars that will determine the degree of the crime and the punishment. And those are all in the particular statute that you have for Pennsylvania. But the core of burglary is an unlicensed entry with the intent to commit a crime. Arson. Arson is another one of these statutes that has a variety of ways in which the statute defines it, identifying the degree of harm. Variations they all include intentionally starting a fire. And as we talked about in class, what is a fire? That seems pretty basic. But is a fire a match? Is a fire a candle? Certainly a fire is a Molotov cocktail. But does it have to be? Can it be the match itself? Can it be a campfire that gets out of control? These are questions that Pennsylvania courts have yet to really answer, in no small part because their decisions on arson still seem to be using the elements from the common law. But we're going to use the statutes for the purposes of our exam. And if I were to ask you a question about arson, I would ask you to delve into the statute and identify questions. Let's say that there were some campers who started the fire, and they thought the fire was out, but they didn't douse it with water. And the fire reemerged and destroyed several, 100 acres and possibly killed someone. Are these campers guilty of the crime of arson? And you'd walk through the various possibilities. A fire was intentionally started, and in that case, the purpose certainly was not to destroy something, but were they reckless with the possibility of destruction of property, or were they reckless with regard to harm? What's the mens rea required for harm? Read the statute, figure that out, and that's how you go about answering a question like that. And the question would be, which degree of arson would their degree of recklessness, if in fact it is reckless, which degree of arson would that satisfy? And is a campfire a fire? Have they started a fire? Is that what the legislature meant in this case? What would be the policy justifications for defining it one way versus the other? Does the fire have to be what's frequently called an incendiary device, something that is meant to cause harm. Or is a fire meant in the terms of campfire? Is the fire meant in terms of candle? Is it meant in terms of match? Conspiracy. Conspiracy is an agreement to commit a crime. Just that simple. Now, while the definition is simple, the facts rarely will be, because you're not going to get, here's our contract to commit a crime that we filed with the Secretary of State. Most often, the cooperation on the crime that's also going to satisfy complicity. Most often, the cooperation on the crime is going to be what shows that there was an agreement. 3 guys go into a bank, all wearing masks, all armed. We can show bank robbery, but we can also show an agreement to commit bank robbery. They didn't just all coincidentally show up at the Farmers and Merchant Bank wearing masks and carrying guns. There had to have been coordination ahead of time. So very often the same facts are going to show that they're all in on this, and will show the agreement. But because that's the common scenario, it doesn't mean it's what we have to show in every case. If you can show the agreement without the crime being committed, and ideally you can, because we'd prefer to catch people ahead of time and stop them, and this will then preview some of our entrapment issues, particularly in the world of terrorism. We would prefer to catch people before they commit the crime. So let's say you do. What are you then on the hook for? Or let's say the crime goes on without you. You've agreed to commit the crime. You're not there for the crime goes ahead. Or we nab you beforehand. What are you liable for? Or even if you're in on it, what are you liable for? Well, there are 2 different formulations of this. One is Pinkerton. That's the 1946 case by Justice Robert Jackson, who was a Nuremberg prosecutor. Under Pinkerton, you are liable for all crimes that are foreseeable from the crime you agree to commit. You agree to commit a robbery, and someone's killed during the course of the robbery. You're on the hook for the robbery. Under the Model Penal Code, you're only on the hook for those crimes for which you share culpability. If the killing is intentional during the course of the robbery, you're on the hook for that. If the killing is reckless and you were reckless, you're on the hook for that. But you have to have that degree of desire. You have to, if you're going to be charged with a first-degree murder that emerges from a robbery, you have to have the intent that's required for that crime to be liable for that crime committed with another's hands as part of the conspiracy you agreed to sign on to. In Pennsylvania, it's not entirely clear whether we follow Pinkerton or the Model Penal Code, though there's a very strong hint from Justice Saylor in his recent opinions that Pennsylvania will follow the Model Penal Code and will abandon its adherence to Pinkerton. Complicity is kind of the opposite end of conspiracy. There is no crime of complicity. And every year someone will write on the exam, this person is guilty of complicity. That is not a crime. You can be complicit in a crime, and you can be guilty of a crime under a theory of complicity. But when you are complicit in a crime, you are guilty of the crime itself. If you are complicit in a bank robbery, you are a bank robber. You're not a complicitor. If you agree to rob a bank, you are a conspirator, guilty of the crime of conspiracy. If you actually rob the bank, then you're guilty of the bank robbery as well. But merely because we've got this title, complicity, does not mean that this is a separate crime. This is a theory of holding you liable for the crime itself. What does it mean to be guilty under a theory of complicity? You have aided the crime. Now, what does that mean? Just because I give gas to someone who's going to rob a bank Does that mean I'm guilty of the bank robbery? Let's say that I know that the person is going to rob a bank. No, it doesn't mean that. It only means that I'm guilty of complicity in my aiding of the crime if I have intended the crime to occur, or with regard to crimes involving harm, if my actions are reckless in bringing about that crime. Two people are drag racing, and one of the drag racers kills someone. I am reckless in recklessly causing someone else to drag race, and that causes a death. I'm not, if we don't kill anyone and I'm just speeding down the highway and that recklessly causes someone to try to race me, I'm not guilty of their reckless driving. If, however, that other person kills somebody, I am now guilty because I have been reckless in encouraging them to commit this crime, to become reckless himself or herself, and thereby running over someone and committing the crime of third-degree murder or involuntary manslaughter. If the crime involves harm in Pennsylvania, and I recklessly cause someone else to join my activity or do their own activity that ends up taking a life or injuring someone, then in Pennsylvania, I am complicit by my recklessness. If it does not involve harm, then under Pennsylvania law, I'm only complicit in a crime if I desire the crime to occur and I aid in its commission. Scope of liability. So let's say I aid someone in committing a crime. I give gas to the guy who's going to rob a bank. I know he's going to rob a bank. I give him gas to go do it with. And how do we prove I wanted him to rob the bank? Let's say I'm getting a percentage. I give him gas and say, hey, will you, he said, he says, I don't have any money on me now. I'm going to rob a bank. All right, how about this? I'll give you the gas, and once you rob the bank, you give me $1,000. I now desire the crime to occur. I am aiding him in robbing the bank. He doesn't have gas money to get there. So I give him the gas. And he agrees to give me $1,000 if the robbery is successful. The fact I now have a stake in the outcome shows I not only aided the crime, but I want it to go forward and be successful. Suppose he shoots someone in the course of this. I have aided him in committing the crime. Am I liable for the death that occurs during the robbery? Under the model penal code, no. Under the common law, absolutely, because it's a foreseeable consequence. Under the model penal code, I'm only guilty for those things for which I bear culpability. If I am reckless in giving him gas to go rob the bank, if I'm reckless with regard to the life of human beings in giving him gas to go rob a bank, and I may be, then I'm liable for the death. If a court finds that I'm not reckless with regard to a life in intentionally causing him to go rob the bank, then I don't have the culpability for that death. I certainly wouldn't seem to have the desire for someone to die. Am I guilty of first-degree murder? No. Felony murder is going to be more complicated in this analysis. And this is worth thinking about. This doesn't have an obvious answer, because felony murder has no mens rea requirement for the killing. And I share the goal by giving him the gas with the $1,000 kickback when he's successful in robbing the bank. I share the goal of the bank robbery. I intend the bank to be robbed. I've helped him go rob the bank. Felony murder requires no mens rea with regard to the killing. Am I complicit in an act of felony murder? That's a really, really hard question. This question is much like the aggravated assault. That specific question is not on the exam. But I highly recommend you think through both possibilities for the answer. This is a great example of something for which I think the answer is far less important than how you would think through that question. I give you gas money, or give you gas to go rob a bank. You cannot pay me. I say, give me $1,000 when you rob the bank. That's our deal. During the course of the bank robbery, you kill someone. Am I on the hook for felony murder? Obviously, there are two possible answers to that, yes or no. Think through, make sure you can explain why each answer would potentially be true under the model penal code. Under the common law, clearly the answer is yes. You'd be guilty even for first-degree murder under the common law. Think through how you would answer this case each way under the model penal code and the way Pennsylvania has interpreted it. Attempt, I shoot at you, I fail. I desire your death. Attempted first-degree murder. Now, attempt law is not as broad as you might think. If I recklessly shoot at you and kill you, then I'm either guilty of involuntary manslaughter or third-degree murder. If I recklessly shoot at you and miss, I've recklessly endangered your life. I've not attempted third-degree murder. You are required to intend the consequence to be guilty of the crime of attempt. You must intend to attempt. So it covers, attempt law covers only a small portion of the crimes, only crimes with the mens rea of intent or purpose. The variety of interpretations that have been given to attempt vary depending on whether we're in an NPC jurisdiction, and for the purpose of attempt, we are in Pennsylvania, or the common law. This is where it's important where this language comes from. If you see substantial step, that language comes from the NPC, and it does not require you to get as close to completing the crime as overt act, which is language that comes from the common law. Defense of self and others. You are allowed to defend yourself. You're allowed to take actions that would otherwise be assault, aggravated assault, even homicide, if necessary to defend yourself or others. What are the principles that are at play? Your use of force must be reasonable and proportionate to the attack that you reasonably believe that you're about to suffer. Deadly force is permitted in Pennsylvania only if death, serious bodily injury, kidnapping, or sexual assault is what you're threatened with. You must retreat if you can do so safely, unless you're in a stand your ground state. Pennsylvania is a stand your ground state. And as I've told you in class, I don't think that particular doctrine affects all that many cases, because you have to be able to retreat with perfect safety or you're allowed to use the deadly force. It's going to be a rare case where someone can say, gee, you were threatened with one of these things, but could have retreated safely. So stand your ground, I think, is more kind of puffery than it is something that affects actual cases. But it is, it's bar examiners love that kind of thing. What's the duty to retreat? Whereas practically the duty to retreat only exists if you can do so with complete safety. And, that's the difference between that and stand your ground just is not that different, in my view. Retreat is not required from your home, or in Pennsylvania, from your car. An unlawful entry into your home or car allows you to assume that is for one of the purposes for which you're allowed to use deadly force. So the castle doctrine, which this is called, is a far more robust doctrine than is the stand your ground. This just says once you're in your house, you're allowed to shoot, so long as you're not being attacked by one of your fellow occupants. Then you still have a duty to retreat, and we've talked about that. But the ability to shoot from inside of to kill from inside your home or car is a very profound thing when there's a presumption that people who are unlawfully entering are doing so for the purpose that allows the shooting. Justification and duress. You're allowed to break the law if doing so would create a lesser evil than you're not breaking the law. And then duress, if you are threatened with physical injury of some sort, force, and this would have caused a reasonable person to commit the crime, you are allowed to commit, or you are excused from committing the crime under a theory of duress. Mistake of fact and mistake of law is one of the more confusing things in the entire criminal justice system. Mistake of fact is a defense to a crime. I thought I was shooting at a deer, not a man. That's a defense. Mistake of law is not a defense. I shot the deer because I thought deer season started on Wednesday, not Thursday. If you're wrong about the law, you do not have a defense. If you're wrong about the facts, you do, because your mens rea is very different. I didn't intend to kill a man because I thought I was shooting a deer. I intended to shoot a deer because I thought I was justified. I thought it was allowed because I thought it was deer season, because you thought it was the wrong. You thought it was the wrong. Oh, you thought deer season started on Wednesday, not Thursday. This can get complicated. I'm going to offer you this caveat just so you can see how it can get complicated, but don't dwell on it too long because it will make your head spin. What if you thought it was Thursday and not Wednesday, and that's why you shot the deer? You knew deer season started on Thursday, but factually, you thought it was actually Thursday. Is that a mistake of fact or a mistake of law? That will get your head spinning. So don't go too far down that bunny trail. But Professor Mystic talked in his video about how this can get really wonky. And there's your example of one way in which it absolutely can. And our final topic was entrapment. It is a defense to a crime if the government works to try to get you to commit this crime. Sting operations are permitted. We need them because things like drugs and terrorism will occur with bad consequences in ways we're not always able to catch. We want to get these folks before they commit the crime, but we also want to get them before they commit the crime, not create people who are now committing a crime who never would have. So what do we ask? How do we define this defense so that we don't punish people who otherwise wouldn't be guilty? Or alternatively, how do we keep the police from engaging in what we would regard to be inappropriate investigatory efforts to cause people to turn to a willingness to commit these crimes? So if the government, first of all, engages in inappropriate tactics, they play upon your weaknesses, it continues to badger you to get you to commit a crime. And if the government agent tells you it's not illegal, which is far less common, or tries to get someone who's not otherwise predisposed to commit this crime to do so, then that is entrapment, and that's a defense to this crime. That second prong we talk about in class as being one that's either objectively or subjectively defined. What exactly does that mean? If we define it objectively, we're asking the question of whether this tactic would have worked on someone who was predisposed. If we ask it subjectively, we say, was this particular defendant predisposed to commit the crime? Why does it matter? Well, the one actually involves testimony about the defendant himself. The other just says what was the behavior the government was engaged in. Pennsylvania uses the objective test. It's designed to deter law enforcement more so than to make sure that this person isn't punished for a crime he or she otherwise wouldn't have committed. Practically speaking, this test is going to produce very similar answers in a lot of cases. Very much like stand your ground, there's a lot of kind of huffing and puffing about which test we should use, but as a practical matter, a lot of cases will come out exactly the same way under both of the tests. So that's the class. That's the summary of the class. That's what we studied this semester. So it was good to have you in criminal law this spring, and best of luck on the exam, and best of luck in the practice of law.